Okay, so I'm going to assume most people can hear me. I think we've got quite a few attendees in now, and thanks, Mark, for the introduction there. Yeah, so basically, Brooks Macdonald, we're an asset management company with offices across the UK. Some of you may have heard of us already. We manage around 13 billion in client assets across our various offices in the UK and the Channel Islands. And my role at Brooks Macdonald really is primarily to head up the corporate protection and personal injury service that we offer and have offered for over 10 years now, but also to work with a number of IFAs, independent financial advisors across the country, and support their interaction really with lawyers. I think more than ever now, from a regulatory standpoint, time's never been better for financial advisors and lawyers to work more closely together. And in one particular area around vulnerability, I think there's a great deal of opportunity as well as risk. And this presentation just aims to give an overview of some of those points, really. So this is kind of a catch-all statement, really, about our aim, at Brooks Macdonald, and our aim also with working with companies like Beaufort from the independent financial advice point of view. If clients are to achieve their outcomes and to be best served in the most suitable products and services to do that, I believe this statement captures our approach, really. And you'll see straight away there are four key groups of people here. There are financial advisors, investment managers, clients themselves who may be vulnerable or not, but obviously for today's presentation we're considering vulnerability, and also those acting on their behalf, which often, if the clients are lucky, is professional representatives from the legal industry, financial services industry, but also, and more we're seeing this these days, it's friends and family and even carers who are getting involved in some of this planning and around this planning issues. And often there's a great deal of misunderstanding about how these people can look after their friends and relatives. Just take a quick look at the agenda for today. Should be around half an hour. And at first glance, you think, well, that's quite weighty in terms of regulatory guidance. But actually, there's some good regulatory research out there from all three bodies listed there. And then we'll just touch on as well in the second section, just working with appropriate independent financial advisors. Before coming to Beaufort, I worked as a financial advisor for a company based in Manchester that deals solely with personal injury, pretty much solely personal injury and corporate protection clients following injury. Most of the clients I dealt with had suffered a brain injury, so I did a lot of work with professional deputies and got a real handle of this whole vulnerability piece as it started coming out from the regulators in around 2015. So we'll just run through some of the research that's been provided and some of the benefits that we can see and the opportunities going forward. Okay, so the first chart, I think working in business development, you're often looking for charts that are going to sit people bolt upright to pay attention. And at first glance, this chart might not quite be that, and especially the colour scheme, I think, could do with some work. What it does is, you can see already, you'll be looking at the data, it's run through the ageing demographic in the UK from a couple of years ago, 2015-16, up to 2035-36. So although the slide could be a little more recent, I think the demographic and the picture is clear. When I look at this slide, straight away, you can see that there's a growing trend as we go across the slide and the charts. If you do some basic maths, though, to make it apparently a bit more dramatic, if you take the number of people on the left-hand side in 2015 and 16, there's around 9 million people. And if you roll that forward to the other side of the chart into 2035-36, there's about 14-15 million people. That's quite a big percentage increase in clients of a certain age or certain age groups, as denoted by the chart. And in particular, one area of interest would be the aged 85 plus area. And these clients are going to require a great deal of changing service over the coming years. And talking about this demographic across the UK with various financial advisory and legal firms, everyone's acutely aware that this is the shape of our client bank for the future. And that vulnerability will cut across this area of a client bank in huge swathes. So straight away, it's obvious that there'll be a whole range of services that needed to be accounted for by both legal and financial services. And groups such as CIFA, who've long worked with the Law Society and now with the SRA to promote independent financial advice, have been touching on this subject recently. And also, we've done some work at Brooks Macdonald in the past months with solicitors for the elderly, and have presented some of this content at some of their regional groups. one of the key points that we liked about our engagement with solicitors for the elderly, or SFE, was their understanding of what it takes to best serve clients who are vulnerable and elderly in particular, not just from a legal standpoint, but also from financial services, but also from other services that can be brought in on behalf of the client by the professional. So it's not about having a siloed business delivery service. It's more about having a signposting awareness that when we're dealing with clients, we know how and when to signpost them to other appropriate services. But more than ever, as I say before, both legal and financial services have great opportunities to work together to ensure clients are adequately protected as they move through later life. Okay, well, one obvious crossover with an aging client bank, but not just aging client bank, as I touched on the corporate protection work as an advisor I've done in the past following injury for many clients, but the 5 key principles of the Mental Capacity Act 2005. So I'm not going to read the slide because I'm sure you're aware of these points already, but obviously it does raise a lot of questions about how best to serve a group of clients who may or may not have capacity or will have fluctuating capacity. And it's a very, very niche and a very difficult area. I actually did a similar presentation to this a year or so ago at a conference, and was approached by a financial advisor afterwards who said to me, what do I do if I've got a client who has power of attorney in place, but unfortunately the attorney seems to me to be vulnerable as well? So I questioned him and said, what do you mean the attorney was vulnerable? What he said is that the attorney was vulnerable because they could not understand fully the services that the financial advisor was trying to deploy on behalf of the donor. So it is a difficult area, and taking decisions on someone else's behalf is a serious matter and needs to be evidenced appropriately on both a financial services and a legal services file. Okay, just focusing quickly now on the FCA guidance on vulnerability. The paper was first launched, the FCA occasional paper, so it says OP8 at the top left, occasional paper 8, in February 2015. And obviously the first sentence points to the fact that the financial services and the regulator are aware about the difficulty vulnerability poses to us as an industry. But I think it's not just applicable to financial services. Here at the same time, we can see that this is also applicable to legal services. But in the bottom section of the slide, we can see we've got the FCA definition of a vulnerable client. And a vulnerable consumer, as it says, is someone who, due to their personal circumstances, is especially susceptible to detriment, particularly, and this is the outcomes focus section, when a firm is not acting with appropriate levels of care. And that's in bold and underlined because from an outcomes focus point of view, under financial services and now under legal services regulation, that's what the regulators are looking for, that a firm is acting appropriately according to each client's different needs. Now, you'll see me smiling and probably might be able to hear in the background some cheering and trampoline bouncing. So I'm just going to pause the audio for a second while I just shut the bedroom window. Bear with me. Hopefully I'm back. We've captured that on the recording as well. Apologies to everyone. I think it's difficult times and need a bit of adaptability, and more than ever, I think the children need a bit of air, and so obviously they're just enjoying a break from homeschooling downstairs. So do stick with me. Okay, so the definition of vulnerability is useful, but again, it's so wide-ranging, as we saw on the last slide, that perhaps it's more useful to consider risk factors for vulnerability or for vulnerable clients. And again, as taken from the Financial Conduct Authority paper back in 2015. So you can see, a good list of areas of cause of vulnerability down the slide. And straight away, I remember working, when this paper came out, I was working as a financial advisor, again, with personal injury corporate protection clients, printed this FCA occasional paper off on the printer just before a weekend, thinking I should glance at this paper over the weekend, and printed it off and found it was 120 pages and littered with onward research, which was a fantastic resource, really. And actually, it's something that SFE, when we were speaking to them, really did use. I wouldn't say as a reference manual, but they took a lot of guidance from and a lot of comfort from the research and the level of research that the FCA had put into the paper. But at the time, for my own kind of advice process and awareness, I was considering clients following injury. One of the factors that the FCA point to is risk factors for vulnerability can be cascading. So the obvious example for me at the time was many of the clients that I would meet who had suffered injury and physical disability would go on to suffer with mental health problems, and would obviously often have people providing care on their behalf, some of them professionally, but quite often there would be friends and family providing a great deal of care for the injured party. So straight away it was obvious to me that the cascading could be an issue, and I'm sure as lawyers you'll be looking at that list, and whichever department of a firm you work in, just the same as it is for financial services, there'll be some clients that spring to mind that are experiencing some of these difficulties, as will the cascading factor. At the same time as looking at the FCA's risk factors for vulnerability, and I think just to make the point about two industries that can come together and work as one to provide services, we can look at the SRA's risk factors for vulnerability as well. So this is lifted straight from the SRA paper on vulnerability, which came out, I think, early 2016. And again, this was a much shorter paper than the FCA's, but again was littered with onward research. And I think lawyers, more than anyone, are well versed in dealing with these characteristics and situations. But again, over time, I think there's an opportunity to grow service capability in that area, not just in line with the ageing demographic slide I showed a few minutes ago, but beyond that. Clients are needing a wider range of support, and I know that the SRA have created papers and plenty of content to promote legal services to clients who might struggle to comprehend the value of services they need and must pay for. And some of the research that they put out there were that clients were just felt awkward about approaching law firms, weren't sure about some of the communication, whether it was a bit jargon heavy, and weren't sure about the payment of fees. And I must say the same applies in financial services, where clients are often just put off by the level of jargon. I mean, particularly from an investment management point of view, Brooks Macdonald, we like to think we're an accessible firm, and we do have a good deal of accessible content for use with an end client. But at the same time, some of our content is just too heavy with jargon. And it's because it's an industry that's been bred on some of the technicalities that effectively over time has been used to sell the services and sell the comfort that the investment management firm understands what the client needs. But at the same time, if it's too jargon heavy, it can become an issue. And one of the big themes of all these papers from different regulators that I've come across in recent years has been about accessibility and inclusion. And again, it's that theme of if clients can't understand the value of the services that they're paying for, and that's a big question mark. If they can't understand the value of those services, that's not the good place to be. And like anyone should understand, if we can make services more accessible for the end user, actually it should promote an increased uptake in demand for those services. Okay, one of the groups that contributed to the FCA paper was the Money Advice Trust. So at the time of reading the paper, the FCA paper for the first time, I'd heard of the Money Advice Trust, but never researched deeply into what they did. The Money Advice Trust is essentially a charity that provides a great deal of coaching for all sorts of service providers in different industries about how to interact with vulnerable clients. So they've done a lot of work with financial services firms, but also firms in other industries. And in this particular slide, I lifted from one of their papers because it's making a point that really, as a traffic light can, vulnerability can move around over time. So everybody on this call, including myself, would be classed as potentially vulnerable. And indeed, at the moment, with what's going on with COVID-19, I think some of us would feel more vulnerable than usual. And when we're looking at our family dynamic and situation, there might well be people in the family who've been affected already. And if not, it's quite likely that it's going to affect most of us going forward. So straight away, it's an acute example of how vulnerability can move over time and very quickly, as we've seen in recent weeks. But it's also an interesting way to mark out a client bank. And quite a few financial advice firms that I've spoken to have used this as a way to just go through, even just taking a spreadsheet of clients and just marking through with a highlighter which clients might fall into which category. And it is a useful exercise. But obviously those most at risk, as the top of the slide says, are those clients who are particularly vulnerable and do need a good deal of adaptation of service provision to cater for their needs. And if that can be evidenced on the file, then obviously from an outcomes regulation point of view, which the SRA are pushing forward on with much more now these days, and especially since the new handbook came in late last year, all of this stuff needs to be evidenced robustly on a file. Just to sidestep for a second from financial and legal services, but just to make a point about the wide-ranging kind of impacts of vulnerability. This slide considers, some price differences between paying for gas and electric, dual fuel tariff via direct debit method of payment, and also by feeding the meter or a prepayment tariff. Before I look at the data on the slide, which I'm sure you'll be looking at already, the source, as it says at the bottom, is from the National Audit Office. So in 2015, Parliament asked the National Audit Office to report on the impacts of vulnerability on consumers across the UK. And they were asked to consider 4 industries. The 4 industries were water, communication, energy, and financial services. These 4 industries were seen as being the 4 industries that all clients, whether vulnerable or not, would interact with at some point during their lifetime. So they wanted to gauge how vulnerable consumers were being catered for. And this slide is probably particularly harrowing for those suppliers, especially to the left of the graph, and I'll talk you through it. So this in the red bars is sort of the bar on the left hand side at £405 a year. The red bar is the difference between people who can afford or are credit worthy enough to be given a direct debit method of paying, and people without the credit history or scores to be able to go on that scheme who are feeding the meter. So a couple of slides ago on the risk factors for vulnerability, it talked about people on low income. Many of these people on low income would also just cross over to the elderly and on low income as well. So what it shows is the supplier 1 on the left-hand side, people who are feeding the meter were paying an extra £405 a year for their gas and electric than someone who was feeding the meter. Now, I live in a 3-bed house in Manchester, and there's 5 of us in the house. It's a little bit tight at times, especially at the moment. But the point is, roughly speaking, I could probably do slightly better than this if I negotiated, but roughly speaking, our quarterly bills on average are about £400 a month. So that shows that over the course of a year, someone who's on a low income vulnerability perhaps, or elderly low income vulnerable, is paying a quarter's extra in terms of fees, which just isn't right. If you scroll across the chart, the various bars show you the different suppliers' differentials. The average of all those bars is in sort of the yellow bar, £226 a year extra people are paying to feed the meter. The difficult part of this graph for the suppliers is when it was considered how much it cost to serve that differential. So the additional cost of serving those feeding the meter was just £54 a year. So straight away as an industry, it's a snapshot of you're not serving vulnerable clients appropriately. Now, if you kind of cast your minds back to I think it was 2014, 15, and certainly after that we had a cold winter as well. But around that time we had an extremely cold winter, and the media were focused on people's ability to pay for energy. And in some, excuse me, in some articles on the media, it was showing elderly people forced to make decisions about whether to feed the meter for heat or to eat. Okay, and when you see that, it gives quite a stark example of the impacts of vulnerability and service provision to vulnerable clients. Usefully, and if you take a look on Ofgem's website, if you Google Ofgem vulnerability, straight away you'd find a lot of content that they've been working on over the past few years. I think it's one of the first industries really to be focused on, and for obvious reasons, given the story I've just told about feeding the meter and paying for food, why that industry had to take action first. But they have since then, grown the use of what's called a warm home discount to kind of level the playing field in terms of paying for energy. Okay, now just to consider, if we've looked at the regulatory background, just to consider some familiar problems. I think this one is fairly obvious, and most private client teams I speak to around the country kind of either raise a laugh or a sigh when looking at this slide. Unfortunately for this consumer, is a female carer who's looking after her mum's finances. I'm not going to read the text, but you can see straight away she's obviously struggling to get service that she should be getting when she has power of attorney. I think there's a great misunderstanding around power of attorney, but in this particular case, it's worth bearing in mind this particular lady who's looking after her mum isn't just speaking to a bank about finances. This lady's got her own life to run, so maybe up in the morning, getting kids ready for school, going to her own place of work, coming home, looking after kids again, before going to look after mum or looking after mum at home, who knows? And I often tell the story, a chap who lives across the road from me here, runs his own business. He's in his early 60s. He runs a business fitting garage doors. Both parents are in their 90s and both have dementia. Now, luckily, in inverted commas, both parents have been in hospital for the past couple of months. Until that point, there was a period of over a year when my neighbour was literally finishing a day's work and going to care for his parents for anything between an hour and staying overnight, because he wasn't getting the correct support that should have been provided from the local authority. Obviously, that has a telling physical effect, especially when you're a guy in your 60s fitting garage doors for a living and then providing this level of care to both parents. But also it's the mental health impact of that as well. But it just gives an example, again, of how difficult it can be to be providing care. And a lot of the statistics show that the level of lay care that will be required in the future in the UK is huge, and it's a growing problem. But again, it's an opportunity for financial advisors and legal service providers to work with clients. And I think even clients around approaching retirement, or certainly at retirement, would benefit from a discussion about how to protect themselves well into the future. And some of that would involve working with a financial advisor, looking at budgeting and the provision of care from a best and worst case scenario basis. And I wouldn't be surprised over time if at some point the cost of care is perhaps factored into pension illustrations to make people acutely aware of what they might have to pay for in the future. And this was something I debated at a Solicitors for the Elderly meeting in the Midlands some months ago, where we discussed the Green Paper on social care. Now, a lot of these things are on hold because of Brexit, if not because of virus. But as we go through time, it'd be good to see some action from the government, and perhaps there'll be a wave of support for the NHS and for social care on the back of the very issues that we're going through at the moment. Okay, so in terms of some of the problems created, the last slide was an example. This is the FCA's list of the impacts of vulnerability. And straight away, as we start at the top, we've got heightened stress levels because of personal circumstances, which could be a huge range of things. I think at Brooks Macdonald, we have a vulnerable client policy in place, as I know do Beaufort. I know many law firms do have a vulnerable client policy in place, which establishes the foundations really for looking after clients in various different situations, but it's not a regulatory requirement as far as I can tell. But when we consider our vulnerable client policy, at first there was a school of thought was to say we need to consider all of the various circumstances that could cause vulnerability to manifest itself with our client base. But of course, we can't do that because there's such a huge myriad of different and overlapping circumstances that can cause somebody to be vulnerable that it's impossible to do so. You can't sort of box every certain situation off and cater for it in a certain prescribed way. So what we did, moreover, was just to create a framework internally that says, let's have a common sense approach to this and be aware of the support that we've got internally and externally to support these clients. Okay, so it's just being aware that other people in the organisation can support clients and being aware of how to behave when we come into contact with someone who's experiencing vulnerabilities. But the heightened stress here can cause increased time pressure and less time for personal admin, which is a problem if you're trying to manage, your just general bills and day-to-day sort of personal admin. And a problem with this is sometimes the brain is elsewhere. And the story I often tell here is one of the family circumstances. Just over 5 years ago, my father died very suddenly, and leaving my mother behind. My mum now lives on her own, but at the time she struggled massively, as my brother and I did, just to administrate the various things that need to be dealt with, via probate, and it was a terrible mess. And some of the institutions we'd be dealing with were not supportive either, didn't have probably vulnerable client policies in place, or certainly if they were, they weren't being adhered to. And to run through the circumstances of my father's death, which my mum had to do with one bank at least 3 or 4 times, was horrendous for us to have to go through. And it shouldn't have happened. But the key point I'm making here is that the brain can be elsewhere. I can't remember a time, and my mum would completely agree with me. Mum's 77 now and very astute, but at this particular point of time, the capacity to concentrate on things for a long period of time was completely gone. It does come back over time, but it's so emotionally draining that obviously it can lead to issues. And this is the very point the FCA are trying to make with this list really here, that this brain being elsewhere and that emotional tiredness that can be a result of a wide range of vulnerabilities just gives us a lack of perspective. And at that point, there's a high risk of making poor decisions. And that's where both financial and legal services providers working together can offer a great support network for clients who need more help. So this slide I found most useful. I've seen quite a bit of guidance over the past few years on what vulnerable clients need. And this came from the Legal Services Board, released in March 2017. And I always say about this slide, if you remove the branding and you remove the titles and you just look at the bullet points, what you see there is good advice for anybody running a business anywhere, a service business anywhere in the world. It's all very straightforward stuff. And I always like the fact that the two research groups that the LSB used for this were not consultancies or anyone that was highly paid to deliver this kind of thinking. It was two research groups, people with dementia in one group and other people with mental health difficulties in the other group. And in both cases, they included the carers offering support to these people. And when you look down the list, it's just plain old common sense. And I have been pulled on this in the past when presenting it, that somebody did say in a meeting, well, this is just basic common sense. Why do we need to be educated around this? Luckily, he was kind of corrected by a lady sitting to his side who said, it might be true that it's common sense, but how can we be sure that within our process, we know each vulnerable client is given the right level of service appropriate to them, which could involve all of the things listed there or just some of them. But it's about being able to evidence that, identifying vulnerable clients, recording them on the system, and then offering them the appropriate level of support. So I do find that slide particularly useful. I think we've seen already, just as I've gone through the slides, that there's a sharp focus from a number of regulators. Financial Services Conduct Authority providing a great deal of research on this, and well worth a look. I mean, as I said earlier, it's a 120-page paper. And they've also released other papers more specifically on ageing population that run to something like 80 or 90 pages. But even just a Google of the FCA paper in 2015 on vulnerability and a look at the executive summary would give a good overview of how this industry is looking to approach that. And again, like I say, again and again, there's more and more opportunity for lawyers and financial advisors to refer clients between each other at the moment. But also other regulators we touched on, National Audit Office, but also societies like the Chartered Insurance Institute, Personal Finance Society have released information on vulnerability. There's plenty of guidance out there. The FCA are going to review actions in our industry in the coming months, perhaps not the next 12 months, perhaps sooner. They released an update on vulnerability in July last year, which there was some disappointment in some quarters because the guidance was no firmer than it was perhaps 4 years previously in 2015. However, my own perspective on that is perhaps it's just a long lead-in period for advisors and financial services firms to get in line. One of the issues for financial services has been that vulnerability can be caused by the very fact that I think at the time of writing their report, the National Audit Office pointed out that there are some 56,000 regulated firms under the Financial Conduct Authority. And if you reflect that back into your own perhaps investment portfolio, perhaps pension plans, perhaps ISAs, perhaps beyond that general insurance, or just maybe the big dusty folder that sits in the loft that I still keep that at some point must be scanned and dealt with differently. But if you think of the amount of brand names of all those financial services providers that we must interact with, in an investment portfolio, for example, that we run as a business, a client could have up to 40 different brand names held within the portfolio because we outsource some of our capability to global financial institutions to manage assets. But it's a scary number of different names, and it can cause in itself its own level of vulnerability. What we're recommending is that firms should embed a vulnerable client policy throughout an organization. And perhaps if you're working with vulnerable clients as a lawyer or financial advisor, it's useful to share that vulnerable client policy between organizations as a due diligence reference point. And I know it's something Beaufort have worked on. I know they have a strong due diligence pack, which is in line exactly with SRA requirements about keeping due diligence about appropriate, sorry, message just popped up there, appropriate financial services. But also, it just gives that framework to refer back to say, okay, this firm does understand what we're talking about and how to support our clients. One area under the FCA regulation that promoted the sharing of vulnerable client policies was around the provision of consumer credit, because at this stage, only consumer credit is the only area of the FCA handbook where vulnerability is mentioned, and it's referring to lending money to people who might be in vulnerable situations. That there's huge overlap between mental health issues and debt, and there's a group called the Money and Mental Health Policy Institute that is purely set up to attack that and are working with banks and lobbying for change in Parliament. It's headed up by Martin Lewis, and again worth a look. But the only area where it's mentioned around sharing vulnerable client policy is under consumer credit. And there's guidance from the Money Advice Trust that said, if you're a bank struggling to collect a loan or get repayments, before you sell that loan onwards to a collection agency perhaps, you must consider the behaviour perhaps of the onward organisation. So it's an important note, and I think we'll see more of that guidance as we go through time. But again, here, it's obvious to state that excellent links with charities are good to see. I know in the legal industry, there's already great interaction between service providers and charities. I know that from working with personal injury claimants in the past, a lot of good work going on. We as a business, and particularly under my own, the proposition of court protection and personal injury, spend a lot of time talking to Headway, and also just forged a closer link and a partnership with the Spinal Injuries Association. And we're learning a lot as we go through our partnership with those firms. And hopefully over time, we'll be able to adapt that into our service provision for the end client. And the aim of that really is to promote the accessibility and inclusion, which is essential for servicing these clients appropriately. Okay, looking at referrals from the SRA, I've touched on a couple of times SRA guidance around referrals, and the areas highlighted in red at the top were from some time ago. But the reason I put them in, even though the regulations changed, the wording there about best interest and clients being in a position to make informed decisions are still within the new handbook, even though it's shrunk from, I think, over 300 pages down to about 100 pages. Those key points are still in there from a principles point of view. The draft regulations obviously came into force. This slide should have been updated. I do apologise. Draft regulations were actually enacted in November last year, and I'm well aware that the compliance officers within firms are often looking for more due diligence about any referee that work is passed to, client work is passed to. And a key factor for this is whether or not the instructed party or the referee, the onward firm, can manage a vulnerable client interaction. But it's quite loose. Outcomes-focused regulation is loose. From a court of protection point of view, I know in the marketplace that we, personal injury court of protection, we take a view that we only accept business through independent financial advisors. So we don't go direct to law firms to look for that kind of business. It's lucrative business, and it creates a good deal of interest from investment managers, as it does from law firms. But if we want to get the right thing done for clients who are extremely vulnerable, we believe those clients should go through an independent financial advisor. And we believe from a regulatory point of view, if the independent financial advisor is suitably placed to conduct research of the whole of the market, and they are highly regulated to do so, then the client journey is more robust. So effectively, if a law firm has good due diligence on a good IFA, then that good independent financial advisor has a good and highly regulated process to make sure clients are given suitable advice. That's the best way to go. But it is, particularly around personal injury and court protection, not always the way things are done. Just considering the financial advice process, many of you will be familiar with this. Many of you will work with independent financial advisors already, and the independence is key. But the financial advice process begins with a fact find at the top. This might include a risk questionnaire, but the fact finding and risk questionnaire is an ongoing process. Advisors are always getting to know clients better and better. From my own experience, not just as a financial advisor, but also as a business development manager, over time, as trust builds between two people or a group of people, the better the service provision can become, because we better understand one another's needs and objectives, and we can help each other to get to where we're going to, but particularly with financial advice. And it's a massively growing area. The number of people requiring advice in the UK is growing, and that means that the number of referrals that can come from financial advice to legal services and vice versa should be in a healthy place going forward. There's often quite a lot of talk of technology today, because of the virus. Obviously, we're presenting remotely and not enjoying, as Mark said, a breakfast butty. But there is surface capability to enact via technology. But moreover, I think clients will require good face-to-face planning into the future, and particularly vulnerable clients and elderly clients. And whether it's face-to-face or via technology, they just want to know they're part of a group of professionals that can help them into their financial and legal futures. And it's all about security. I think that the one report my mum often smiles with me about that she'd like to get hold of is a report that would say to her, how does she get, quite a cheery subject, I don't know how you'd title the report, but it's how she gets from age 77 to the grave as comfortably as possible by paying for care, whether that be domiciliary or residential, sourcing any appropriate care payments she can from local authority NHS and getting the right support. And then after that, and being sure of that and the costings of that, being able to pass on any residual assets. I think that kind of report has got a strong place, and there's a strong demand for that. I'm speaking to a number of law firms around the country in recent months, I think there is a strong appetite to work with financial planners to provide that kind of cash flow report, in line with more support around power of attorney, wills and estates, for example. So we consider fact-finding and risk questionnaires on a regular basis. Also, a cash flow analysis, which helps clients understand when a pot of money could run out. So obviously very relevant to paying for care, etc. Also for personal injury claimants, it is vital to know how long that money will last and to account for various different indexation indices around payments for care. Everyone always asks, what is PIPSI at the bottom of the slide? PIPSI is the order in which holistic financial advice should be given. So it should never be assumed, for example, that a client has an investment need, and this makes the point. Here, it points out that when financial advice is being provided, it should consider this order. And PIPSI is protection, so life insurance, for example, then income, so budgeting support, including any welfare benefit support or support in terms of paying for care, then pensions planning, then savings, and then finally, after all the others have been accounted for, there might be an investment need which should only be approached at that point. And it's important to note that, because you should feel that when working with holistic financial planners, that all of these things are evidenced and catered for regularly. And then obviously we work through implementation, but the important thing to remember is that all of this is under regular, annual or more frequent review by the financial advisor. And I think there's a great benefit for advisors working with lawyers there, because there is, if you're working with a good financial advisor, good financial planner, they will, via regular review, uncover more opportunities for referrals for law firms. So just as the same slide, slightly different wording, this is the benefit and value of IFA services. If you've got whole of market support and you've got a good financial advisor, okay, that's providing whole of market research on a regular basis, you've then got maximum due diligence on behalf of your client in a referrals process. For me, that reflects back on the SRA slide, 2 or 3 slides ago. If you've got maximum due diligence, you've got maximum suitability within the recommendation from a client. That has to be front and center when acting in a client's best interests and making sure the client is wholly informed or fully informed about the referrals process. Now, you can read into what being fully informed means, but I think on any file, if there's good due diligence between lawyer and financial advisor, and perhaps vice versa, but also then the independent financial advisor has got strong due diligence on onward service providers such as ourselves, in the event of a complaint from a client, there's a very robust file that everybody tried to do the right thing. Complaints will happen whether or not that client satisfaction is key, but complaints will happen anyway. But if the due diligence file can be evidenced robustly, I think it's a strong place to be. But maximum due diligence provides maximum protection, as the slide said. PIPSI again is making the point of holistic financial planning. Tax wrappers are essential. Financial advisors, again, we work with advisors providing investment solutions, but the independent financial advisor will ask us to run portfolios within certain tax wrappers to make the most of the tax benefits of those wrappers. And again, the independent financial advisor uses a whole of market research framework to make sure the most robust, cost-efficient tax wrappers are being used and managed in the right way. And if this process is followed, we get maximum impartiality through the advisor independence, full flexibility of service because of the annual review, and also maximum suitability. Just reflecting back on the point I made earlier about Brooks Macdonald and our approach to personal injury court protection work, we don't go directly to law firms, we go through independent financial advisors. We think it's the most robust way to go, and we think it's more responsible for us to fight for business with independent financial advisors, because they are regulated to take account of our service provision, our costs, charges, risk management, investment process, and evidence that on their file. So we fight for business with them. And I think most of the law firms that we've presented to over recent months have found that maybe a slightly different approach, certainly from a personal injury point of view. But I think from a wider aspect, it's just that robust due diligence process that goes from service provider to service provider and can be evidenced repeatedly. Okay, just a quick point there on intergenerational planning. Vulnerability in an aging client bank also lends itself to intergenerational planning and intergenerational wealth transfer. There's been plenty of articles written and plenty of research conducted in the financial services industry, and I know some also, for obvious reasons, in the legal industry. This passage, which I'm sure you're reading already, came from the research Brooks Macdonald did, I would say, about a year ago, 6 months to a year ago. We've got more work to do around our research in this area, because we've got to cater for vulnerability. We've got a vulnerable client policy on one hand, we've got our research and intergenerational planning on the other, but we need to bring the two together and consider our client bank and the effect on that client bank of a changing regulatory landscape. But there'll be opportunities to support clients better, and we can see here that there's a big number, 300 billion will be transferred to around 300,000 inheritors over 10 years. And the paragraph on the right-hand side puts that into context against the 274 billion currently administered by advisor firms for private clients. So there's a big market out there, and there's a lot of wealth that's going to be transferred. There's a lot of things that will impact wealth transfer, and especially impact the younger generation maintaining a financial advisor or a legal advisor after assets have been transferred. Some of the research has suggested technology will be a key factor. So the younger generation will want to be able to interact via a platform and be able to get valuations or access to legal services remotely. Other research says that the younger generation will want to see, from an investment point of view, more ethical consideration given. And there's a hell of a lot of research out there about ethical investments at the moment, and we'll only see more and more of it. But for me, looking at vulnerability, and just from a personal point of view, what would I want to see from a financial advisor or legal advisor working with more and more, or grandparents in later life? You'd want to make sure that they've been given the right advice and support about access and paying for care. That would give a great deal of peace of mind, and I think would have a great knock-on effect, because any family that's brought into a room to talk about those issues should feel the benefit of legal and financial services working closely together. There's not many cartoons out there about paying for care, but this one makes the point quite starkly, really. The cost of care is great in the UK. We work with a law firm called CMS, an international law firm, when we reapproached our own vulnerable client policy, and there was a lot of data on their website about paying for care in the future and the numbers that are required and the shortfall of care provision in the UK. But it's something, as I've touched on, we should all be acutely aware of, and perhaps working with advisors to consider the cost of care and options for paying for care in the future is something that clients will be pleased to receive. So just in summary, before the compliant wordings go onto the screen, the aim of this presentation, really, I'm not going to run through a wide summary, is exactly our aim. We want to promote the best financial advice and investment management services for vulnerable clients and those acting on their behalf, which includes lawyers and also friends and family and other professionals. So anything we can do to promote this message, we're grateful to receive the airtime. And I'd like to thank Beaufort for letting us present today on the screen. I'd have preferred to do it face-to-face, but I'm sure there'll be other opportunities in the future. And at that point, I'll open up for questions, which I think means I hand back to Mark.
Hi everybody, thank you very much. Hope you can all still hear me. Thank you, David, that was excellent and very much appreciated. Just from our perspective, just a couple of things. Does anyone have any questions? Please feel to type them down below if you do. I think Kaylee's typing as we speak, as is a couple other people as well. So let's just take these questions, David, and we'll see what we come up with. Just where I've got you, what I've done, can everyone hear me okay? Just where I've got you, I've just put a link down to our future events that are coming on. We have another couple of webinars that we'll be holding, one with CIFA regarding the new SRA rules, which I think in particular the co-ops of your businesses will find useful. And another one towards later in the month regarding the investment markets and what's going on in the world, which obviously has been quite a volatile time over the last 2 or 3 months, well, sorry, 2 or 3 weeks in particular. So I'll just put the link in terms of our events from here. Hopefully you can see those. I think we had one question coming in, David, from Kaylee, but nothing at all as yet. So what I propose to do, if that's okay with everyone, is we've got your details. We will send across the slides for you, as well as the information relating to the upcoming seminars as well. Just really quickly from our perspective, we focus and have focused on the last 2-3 years, constantly continuing to talk about collaboration and the importance we feel that our clients and the benefit they get from that. We want to work alongside professionals to make sure our clients have the best advice and, more importantly, achieve their goals. That's the most important thing for us. So we really appreciate your support over the last 2 or 3 years, and in particular going forward as well. All our clients benefit from the cash flow model that David talked about, whether it's retirement, long-term care planning, inheritance tax planning. We can build a model for them to make sure they achieve their goals, as I mentioned earlier on, which again is really important from our perspective. And each and every single one of our clients goes through an annual review meeting at a bare minimum. So depending on the proposition they have agreed to with us, we can see them anywhere between 4 and once a year. So really importantly, we'll have regular contact, and as their circumstances change, we'll be looking to forward them on to people such as yourself to try and make sure their estate and personal needs are looked after as well. So I hope you found that useful. Really appreciate your patience and apologise for any technical glitches. We will get better at this, as you appreciate that the world's a slightly different place than it was 3 or 4 weeks ago. So without further ado, I'd like to thank you again. We've got a few people typing at present, so just before we go, we'll just find out. Thank you, Richard. That's fantastic. You're very welcome. A few other people typing. David, you got some great feedback, which is great, which is very much what we hoped for. So thank you very much for that. So I think if that's okay, what we'll do is we'll call the presentation to an end there, and thank you all very much again for your time. So we will speak to you again soon. Take care, and we'll see you hopefully in a couple of weeks' time. Thanks again.